October, we welcome our first guest this morning. That guest is Christopher Green. He is a law professor in the School of Law at the University of Mississippi. He is the Jamie L. Whitten Chair in Law and Government. Christopher, good morning. Appreciate some of your time. Thanks for stopping in.
Oh, thanks for having me again.
So let's jump into something that was happening in the last few days at the Supreme Court, and maybe actually want you to take us back a little bit farther. They are taking up and hearing oral arguments regarding the decision to regulate the kits used to make the so-called ghost guns. Those are the kind of home assembly firearms. But if we could go back a little bit farther before we talk about exactly what happened there. How does this conversation get to the Supreme Court level? What happened to get us to this point where the Supreme Court was hearing these arguments?
Right. So first thing you have this longstanding statute about guns. I think the provision that they're particularly fussing about was in 1968, but you have this term that's used in lots and lots of statutes, gun. And guns have to have serial numbers, but they discovered over the course of time, just as technology develops, as the ability to do kits develops, there were a bunch of these relatively easily assembled kits for guns. So in 2022, Biden administration says, well, we think the term gun in the statute includes these, and there's some terms, frames. I learned more about the engineering of these guns with all these things, but there's a term about frame. But anyway, they issue a regulation saying these kits also need to have serial numbers so that we can keep track of this as well. And so they put the regulation in effect. It gets enjoined, so it gets prevented from being enforced by a district judge. And then the Fifth Circuit, which is Mississippi, Louisiana, Texas, they say they agree with the trial court. But then in August, the U.S. Supreme Court says 5-4, we are going to issue a stay. So they don't really say a lot about the merits. They don't say anything at all about specifically about the reasoning. But they say, well, we're going to put the regulation back into effect. We're gonna have a stay of that. So because of that, we actually have a pretty good sense of at least where they're starting in terms of the counting to five question. Can you get five justices to go either way? So basically, you have this relatively new regulation of an old statute about this term gun. So it's sort of like a metaphysical question. What is a gun? So you get this kit in the mail. Is it a gun yet? Is it not a gun until you assemble it? That's basically the question in the case.
So Peter Patterson is the attorney who's representing gun owners, groups, and makers of these kits, is arguing that these are not actually guns. And the other argument, and I think it was Chief Justice Roberts, who seemed a little surprised with this argument, saying that, look, you're just drilling a couple of holes. It's a 3D printer. You put it together and boom, sorry for the bad pun, you've got a gun. What is the argument that Patterson is making on behalf of gun owners and the makers of these kits that are available through mail order?
Yeah, so I think the argument, the most vivid piece of argument on that side, Justice Alito, actually, he had a couple of illustrations. He said, so the term that the administration is promoting is readily convertible. So you've got this kit. It's not that much to do in order to change it into an actual gun, and it's not anything else now. Okay, so. Justice Alito says, well, wait a minute. I've got a pad of paper. He holds up a pad of paper and a pen, and he says, is this a shopping list? Well, it could be readily converted into a shopping list. And they say, well, no, that's not a shopping list because it's something else. It could be used for, a list of things you need to to-do list instead of a shopping list. He said, and then he had a secondary illustration. If you have all the ingredients for a Western omelet, and he knows better what goes in Western omelets. He lists all these ingredients, and he says you put them all together. Is that a Western omelet. So intuitively, a bunch of parts that could be assembled into a gun is not yet a gun. Justice Barrett, actually, at that point, once in a while, you'll see him ask questions that are clearly answers to the previous question. And she gave a little ad for HelloFresh. So I guess HelloFresh sends you kits with really, exactly as much ingredient as you need. And they said, well, if you had a HelloFresh chili thing, would that be chili? She clearly thinks that it would be. And you look at this thing, is it, what would you say it? Would you have to say it's a kit from which you could make a gun, or it's just an unassembled gun? So it's like, what is a gun? When do you cross that boundary into gunhood? So there's a question about our pants shorts, because they could be readily converted into shorts by just chopping off a part of the pants. The Solicitor General said, well, no, because there are pants, because they are another thing. Whereas this kit, all it is a potential gun, and a very, very close to a gun.
So you have this big bookshelf behind you that's loaded down with law books and whatever else that's on there. Let's just pretend for a second that is a bookshelf from IKEA. And
right. Much discussion of IKEA in the argument.
Yeah, I mean, if you've ever put together anything from IKEA, you know that there is little that makes you want to ram your head through a sheetrock and hope you don't hit a stud than assembling that. But the package says bookshelf, so you've got to ultimately put it together. I guess it's the same argument that you're making there, right? Is the box with all of the parts in it a bookshelf, or do I have to actually assemble this before it becomes a bookshelf? And I don't know,
That's right. So readily
bookshelf after the fact. I don't know.
Yeah, the readily assemblable or readily convertible. That adverb readily is going to definitely have some fuzzy edges. So they're talking about, so Alito's like, well, what about people who are really bad at assembling things? So I always remember, back when I was, I made a treehouse in the backyard. So one of the ones, I got some kit from Home Depot, and they said it takes about 8 hours. I'm thinking absolute minimum 40 hours for me. So that was
maybe. Yeah,
that was a whole bunch of Saturdays for that. So you do sell kits, right? It's a thing that you do to enjoy assembling them. So the gun owners were, they said, well, some people might like to put together their own gun. And that's true. I mean, I do know kids that, they love to just learn about all the mechanics of, the future engineers of the world. They do that. These were pretty simple to assemble, I think. So the SG said, look, I made one of these myself. It is not it's not a craft type experience. It's just, they're trying to make it as simple as possible, while they think are having an argument that they're technically complying with the law. And the advertising that some of these things do is not helpful for their cause, because they say this is super simple. That kind of language gets used, and if you're specifically saying this is something that you can turn into a gun super easily, and it's not really anything else, I think there's a lot of intuitive force to think. It doesn't make a whole lot of sense to require serial numbers for a gun, but not require a serial number for this. It's just a question. Well, Congress could have done it. I think that's one of the stronger arguments on the other side. This is something that, they consider for a reasonably long length of time. Congress has been in session. There's nothing secret about it, so there's no real need for the executive branch to be doing this. I always say, well, what do you need executives for? Stuff that is secret and stuff that has to happen fast. Congress operates relatively slowly and in public, but it could have passed this if it wanted to. So intuitively, I think that's a big part of the argument on the other side, is that the administration could have just proposed this to Congress, and they know that there's enough support for just really unregulated guns that wouldn't have passed. But that's our system, that we have gridlock and we have a bicameral system, yada yada yada. It's hard to pass stuff, but Congress has the legislative power. So that's, I think, the biggest argument on the other side.
Christopher Green, law professor at the University of Mississippi, thank you for shedding a little bit of light on this issue, and we'll see where it goes from here. 20 seconds or less, we're up against a break. What happens next? Does the Supreme Court make a ruling, or are they going to hear more arguments?
So on Friday they'll get together and have their conference. They'll say what they think. I think they're probably assign the opinion to somebody. It's possible this will be clear enough that it'll get have an opinion within a month or two. If they have a significant dissent, clearly Alito was pushing back with some vigor. It could be several months, but definitely by the end of June, and probably I think a lot earlier than that.
Very good. Christopher Green, law professor at the University of Mississippi, Ole Miss School of Law. Professor Green, thanks so much for your time.
Good talking to you.
You as well. This is the Gallo Radio Show on SuperTalk, Mississippi.